And I'm updating the exhibit sticker on the USB to account for all of the ones that were added.
Oh. And then are you gonna have a clean computer for them?
That's what this one is,
Is
and
that one? Okay.
I'm very glad that I checked it. It still had stuff from Angela's trial.
Oh, no.
Yeah, I know.
Okay. Thank you. Please get brought up, Judge.
Exhibit sticker?
No, I've just kind of been adding commas to this one.
Okay.
Okay. So we have. I might have to make this next one over. Just enough room.
We are back on the record on docket 25-1892 FC, people of the state of Michigan versus Alyssa Clark.
No.
I'm sorry, that's it. People of the state of Michigan versus Andrico Brooks. No idea why I just did that.
That was a new one.
Yes, that was a new one. All right, so it's against Mr. Brooks. All right, everybody is here, and I understand this morning, a couple things have happened. We have all of the evidence in order. We have a clean computer if the jury needs it, and there's some changes to the jury instructions.
Yes, Your Honor, and I can make a very brief record of those.
All right, well, what are those?
So first, there was a expert witness instruction left over from a prior trial that was taken out. Secondly, when I was discussing the trial afterwards with my colleagues upstairs, they informed me that for receiving concealing of a stolen firearm, it is not, due to new case law, it isn't that the defendant knew, had a reason to know, or should have known that the firearm was stolen. It is the defendant knew it was stolen. So the jury instructions have been modified to reflect that. I don't believe any curative instruction is needed simply because the instruction is in there. It's been said many times, even by me. The law is what the judge gives it to you, not what either the attorneys say. So now that that has been changed, I don't believe that there is any issue.
So, I'm sorry, is it that he knew? Is this one,
Nope,
is this the old one?
yeah, that's the old one. Your new one's in your stack
Okay.
on the page number.
So now, instead of saying defendant knew or had reason to know, or reason to believe, it says defendant knew that the property was stolen, is that correct?
Correct.
Okay,
And that should comply with the recent case law.
and is that on all kinds of property or just weapons?
Just the firearm charge. I mean, quite literally, it's just for if the stolen receiving property is a firearm. For that separate crime, it isn't, should have known, it's new.
All right, I checked my version and it is correct, I'm getting rid of the old one. And this one was taken out,
Yes,
that should not have been
correct.
correct. Everything else correct?
It is, Your Honor.
Have defendant?
Good morning, Your Honor. Thank you. I concur with the comments offered by Mr. Pfeiffer with respect to the instructions. Some have been mutually agreed to be deleted, and the one that counsel just informed the court to be modified. Of course, we have no objection to that. Any other concerns or objections were addressed by the court yesterday, so I have no other concerns. Thank you.
Thank you. One final matter. Do we need to go off the record a moment?
Maybe.
What we're trying to confirm is what we have here is being read today, all that goes back with them? Because if what was read at the beginning of trial goes back with them, we have to change the elements there as well.
They already have those.
Yeah,
Okay,
but they have the old elements in that one, so do we need to?
that's,
Well, I can tell them that there's been a recent change, so they are to ignore, or I can tell them that this replaces in full the initial ones.
I think there's been a recent change. Please ignore the earlier elements and go with what is currently here.
Okay,
I think that would solve things.
all right,
Thank you, Buxton.
agreed.
Yes, Your Honor.
Okay.
Yes, thank you.
The other question that I have is, I had modified the exhibits so that the Court of Appeals can have unredacted whatever they want. If they want it, should it go there? But I want the jury and anybody else to have the redacted social security, et cetera. Has that been done?
I misunderstood. I thought you only wanted that to go into the appeals.
Well,
So what I can do is I can simply take a marker to it.
the jury has no reason to have those numbers. I think they're all honest good people, but I don't know where it's gonna land. So the only one that should have is the Court of Appeals.
I'll identify which ones they are. It shouldn't slow down our instructions today. And then as soon as they're sent back there, I'll get them redacted.
Okay,
before it goes back to the jury.
you and counsel can confer on that. Is that
Yes.
agreed, sir?
Yes, Your Honor, thank you. And I too am anticipating the first note out is for the exhibits, so that would be appropriate. Thank you.
I'll have it done fast.
And if you want to take a minute and do it now or do it while I'm reading, that's fine. We just, if you want to agree that they just all go back. The issue that I will have and always have is that the gun will not go back.
Understood, Your Honor.
Yes, Your Honor, thank you.
And if they want to see it, they can come out here and see it with law enforcement.
That's appreciated, Your Honor.
All right, thank you. The jury, please.
All right.
Good morning, thank you, you may be seated. Members of the jury, the evidence and arguments in this case are finished, and I will now instruct you on the law. That is, I will explain the law that applies to this case. Remember, you've taken an oath to return a true and just verdict based only on the evidence in my instructions on the law. You must not let sympathy, bias, or prejudice influence your decision. You must avoid reaching conclusions that may have been unintentionally influenced by stereotypes. You must reach your own conclusions about this case individually, but you should do so only after listening to and considering the opinions of the other jurors who may have different backgrounds and perspectives from yours. As jurors, you must decide what the facts of this case are. This is your job, no one else's. You must think about all the evidence and then decide what each piece of evidence means and how important you think it is. This includes whether you believe what each of the witnesses said. What you decide about any facts in this case is final. It is my duty to instruct you on the law. You must take the law as I give it to you. If a lawyer says something different about the law, follow what I say. At various times, I've already given you some instructions about the law. You must take all of my instructions together as the law you are to follow. You should not pay attention to some instructions and ignore others. To sum up, it is your job to decide what the facts of this case are, to apply the law as I give it to you, and in this way, to decide the case. The instructions I'm reading, as it happened with the earlier instructions, you'll each have your own copy to refer to. So again, you can take notes as to what I'm saying, but you don't have to. Just make sure you pay attention regardless. A person accused of a crime is presumed to be innocent. This means that you must start with the presumption that the defendant is innocent. This presumption continues throughout the trial and entitles the defendant to a verdict of not guilty unless you're satisfied beyond a reasonable doubt that he is guilty. Every crime is made up of parts called elements. The prosecutor must prove each element of the crime beyond a reasonable doubt. The defendant is not required to prove his innocence or to do anything. If you find that the prosecutor has not proven every element beyond a reasonable doubt, then you must find the defendant not guilty. A reasonable doubt is a fair, honest doubt growing out of the evidence or lack of evidence. It is not merely an imaginary or possible doubt, but a doubt based on reason and common sense. A reasonable doubt is just that, a doubt that is reasonable after a careful and considered examination of the facts and circumstances of this case. When you discuss the case and decide on your verdict, you may only consider the evidence that has been properly admitted in this case. Therefore, it is important for you to understand what is evidence and what is not evidence. Evidence includes only the sworn testimony of witnesses, the exhibits admitted into evidence, and anything else I told you to consider as evidence. Many things are not evidence, and you must be careful not to consider them as such. I will now describe some of the things that are not evidence. The fact that the defendant is charged with crimes and is on trial is not evidence. The lawyer's statements and arguments are not evidence. They are only meant to help you understand the evidence and each side's legal theories. You should only accept things the lawyers say that are supported by the evidence or by your own common sense and general knowledge. The lawyer's questions to the witnesses and my questions to the witnesses and also your questions to the witnesses are not evidence. You should consider these questions only as they give meaning to the witnesses' answers. My comments, rulings, questions, and instructions are also not evidence. It is my duty to see that the trial is conducted according to the law and to tell you the law that applies to this case. However, when I make a comment or give an instruction, I am not trying to influence your vote or express a personal opinion about the case. If you believe I have an opinion about how you should decide this case, you must pay no attention to that opinion. You are the only judges of the facts, and you should decide this case from the evidence. At times during the trial, I've excluded evidence that was offered or stricken testimony that was heard. Do not consider those things in deciding the case. Make your decision only on the evidence I let in, nothing else. Your decision should be based on all the evidence, regardless of which party produced it. You should use your own common sense and everyday experience and general knowledge in weighing and judging the evidence, but you should not use any personal knowledge you may have about a place, person, or event. To repeat once more, you must decide this case based only on the evidence admitted during this trial. It is your job to decide what the facts of this case are. You must decide which witnesses you believe and how important you think their testimony is. You do not have to accept or reject everything a witness said. You are free to believe all, none, or part of any person's testimony. In deciding which testimony you believe, you should rely on your own common sense and everyday experience. However, in deciding whether you believe a witness's testimony, you must set aside any bias or prejudice you may have and not be influenced by a witness's disability, gender identity, race, religion, ethnicity, sexual orientation, age, national origin, or socioeconomic status. Again, take the time you need to test what might be automatic or instinctive judgments, and to reflect carefully about the evidence. There are no fixed set rules for judging whether you believe a witness, but it may help you to think about some of these questions. Was the witness able to see or hear clearly? How long was the witness watching or listening? Was anything else going on that might have distracted the witness? Was the witness able to see or hear clearly? How long was the witness watching or listening? Does the witness seem to have a good memory? How did the witness look and act while testifying? Did the witness seem to be making an honest effort to tell the truth, or did the witness seem to evade the questions or argue with the lawyers? Does the witness's age and maturity affect how you judge his or her testimony? Does the witness have any bias, prejudice, or personal interest in how this case is decided? Have there been any promises, threats, suggestions, or other influences that affect how the witness testified? In general, does the witness have any special reason to tell the truth or any special reason to lie? All in all, how reasonable does the witness's testimony seem when you think about all the other evidence in the case? Sometimes the testimony of different witnesses will not agree, and you must decide which testimony you accept. You should think about whether the agreement or disagreement involves something important or not important, and whether you think someone is lying or simply mistaken. People see and hear things differently, and witnesses may testify honestly, but simply be wrong about what they thought they saw or remembered. It is a good idea to think about which testimony agrees best with the other evidence in the case. However, you may conclude that a witness deliberately lied about something that's important to how you decide the case. If so, you may choose not to accept anything that witness said. On the other hand, if you think the witness lied about some things but told the truth about others, you may simply accept the part you think is true and ignore the rest. The defendant is charged in count 1 with the crime of torture on or about May 25th, 2020. To prove this charge, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, that defendant had custody or physical control over Alyssa Clark. This means that defendant used force or threat of force either to confine Alyssa Clark by interfering with her liberty or to restrict Alyssa Clark's freedom of movement. Second, that defendant exercised custody or physical control over Alyssa Clark without her consent or without lawful authority to do so. Third, that at the time defendant had custody or physical control over Alyssa Clark, he intentionally caused great bodily injury or severe mental pain or suffering to Alyssa Clark. Great bodily injury means causing a serious impairment of a body function, which includes any of the following: loss or substantial impairment of a bodily function, serious physical disfigurement, a skull or other serious bone fracture, or means intentional injury, poisoning, serious burns or scalding, severe cuts, or multiple puncture wounds. Severe.
That was internal injury, not intentional injury.
Oh, sorry. Okay. Internal injury, sorry, or means internal injury, poisoning, serious burns, or scalding, severe cuts, or multiple puncture wounds. Severe mental pain or suffering means a substantial change in mental functioning that can be perceived by another person. It must have been caused by defendant in one or more of the following ways: intentionally causing great bodily injury to Alyssa Clark or threatening to cause great bodily harm to her. Threatening Alyssa Clark with an imminent death or threatening that another person will imminently be killed, subjected to great bodily injury, or given a mind-altering substance meant to disrupt the senses or personality. Fourth, that defendant intended to cause Alyssa Clark to suffer cruel or extreme physical pain or mental pain and suffering. The prosecutor does not need to prove that Alyssa Clark actually suffered any pain. Defendant is charged in count 2 with the crime of assault by strangulation or suffocation on or about May 25th, 2020. To prove this charge, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, that defendant committed a battery on Alyssa Clark. A battery is a forceful, violent, or offensive touching of another person or something closely connected with that other person. Second, that the touching must have been intended by defendant, that is not accidental, and it must have been against Alyssa Clark's will. It does not matter whether the touching caused an injury. Third, that the battery was committed by strangulation or suffocation. Strangulation or suffocation means intentionally impeding normal circulation of the blood or breathing by applying pressure on the throat or neck or by blocking the nose or mouth. As used in these instructions, the words force and violence mean any use of physical force against another person so as to harm or embarrass her. For a battery to occur, the touching must have been intended by defendant. That is not accidental. And it must have been against Alyssa Clark's will. It does not matter whether the touching caused an injury. An assault does not have to cause an actual injury. However, if there was an injury, you may consider the injury with the other evidence in determining whether there was an assault. Defendant is charged in count 3 with the crime of assault by strangulation or suffocation on or about the year 2020. To prove this charge, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, defendant committed a battery on Alyssa Clark. A battery is a forceful, violent, or offensive touching of another person or something closely connected with that other person. Second, that the touching must have been intended by defendant, that is not accidental. And it must have been against Alyssa Clark's will. It does not matter whether the touching caused an injury. Third, that the battery was committed by strangulation or suffocation. Strangulation or suffocation means intentionally impeding normal circulation of the blood or breathing by applying pressure on the throat or neck or by blocking the nose or mouth. Defendant is charged in count 4 with the crime of assault by strangulation or suffocation on or about June 2020. To prove this charge, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, the defendant committed a battery on Alyssa Clark. A battery is a forceful, violent, or offensive touching of another person or something closely connected with that other person. Second, that the touching must have been intended by defendant. That is not accidental, and it must have been against Alyssa Clark's will. It does not matter whether the touching caused an injury. Third, that the battery was committed by strangulation or suffocation. Strangulation or suffocation means intentionally impeding normal circulation of the blood or breathing by applying pressure on the throat or neck or by blocking the nose or mouth. Defendant is charged in count 5 with the crime of assault with intent to do great bodily harm less than murder on or about the month of May 2020. To prove this charge, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, that defendant tried to physically injure another person. Second, that at the time of the assault, defendant had the ability to cause an injury or at least believed that he had the ability. Third, that defendant intended to cause great bodily harm. Actual injury is not necessary, but if there was an injury, you may consider it as evidence in deciding whether defendant intended to cause great bodily harm. Great bodily harm means any physical injury that could seriously harm the health or function of the body. Defendant is charged in count 6 with domestic assault on or about May 25th, 2020. To prove this charge, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, that defendant assaulted or assaulted and battered Alyssa Clark. A battery is the forceful, violent, or offensive touching of a person or something closely connected with him or her. The touching must have been intended by defendant, that is not accidental, and it must have been against Alyssa Clark's will. An assault is an attempt to commit a battery or an act that would cause a reasonable person to fear or apprehend an immediate battery. Defendant must have intended either to commit a battery or to make Alyssa Clark reasonably fear an immediate battery. At the time of an assault, defendant must have had the ability to commit a battery or must have appeared to have the ability, or must have thought he had the ability. Second, that at the time Alyssa Clark was a person with whom defendant had or previously had a dating relationship. A dating relationship means frequent, intimate association primarily characterized by the expectation of affectional involvement. It does not include a casual relationship or an ordinary fraternization between two individuals in a business or social context. Defendant is charged in count 7 with home invasion in the first degree on or about May 25th, 2020. To prove this charge, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, that defendant broke into a dwelling. It does not matter whether anything was actually broken, however, some force must have been used. Opening a door, raising a window, and taking off the screen are all examples of enough force to count as a breaking. Entering a dwelling through an already open door or window without using any force does not count as a breaking. Second, that defendant entered the dwelling. It does not matter whether defendant got his entire body inside. If defendant put any part of his body into the dwelling after the breaking, that is enough to count as an entry. Third, that when defendant entered, was present in, or was leaving the dwelling, he committed an assault. Fourth, that when defendant entered, was present in, or was leaving the dwelling, another person was lawfully present in the dwelling. In the alternative, you may consider the theory of home invasion in the first degree, entering without permission. To prove this charge, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, that defendant entered a dwelling without permission. It does not matter whether the defendant got his entire body inside. If defendant put any part of his body into the dwelling without permission, that is enough to count as an entry. Second, that when defendant entered, was present in, or was leaving the dwelling, he committed an assault. Third, when defendant entered, was present in, or was leaving the dwelling, another person was lawfully present in the dwelling. Defendant is charged in count 8 with preventing or attempting to prevent a person from reporting a crime committed by another person on or about May 25th, 2020. To prove this charge, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, that defendant prevented or attempted to prevent Alyssa Clark from reporting that defendant had assaulted her. Second, that defendant used physical force against Alyssa Clark when preventing or attempting to prevent her from reporting that assault. Third, that defendant's use of force involved committing or attempting to commit the crime of interfering with electronic communications, as I will later describe for you. Defendant is charged in count 9 with the crime of assault with a dangerous weapon between June 2020 and November 2020. To prove this charge, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, that defendant either attempted to commit a battery on Alyssa Clark or did an act that would cause a reasonable person to fear or apprehend an immediate battery. A battery is a forceful or violent touching of the person or something closely connected with the person. Second, that defendant intended either to injure Alyssa Clark or to make Alyssa Clark reasonably fear an immediate battery. Third, that at the time defendant had the ability to commit a battery, appeared to have the ability, or thought he had the ability. Fourth, that defendant committed the assault with a dangerous weapon. A dangerous weapon is any object that is used in a way that is likely to cause serious physical injury or death. Some objects, such as guns or bombs, are dangerous because they are specifically designed to be dangerous. Other objects are designed for peaceful purposes, but may be used as dangerous weapons. The way an object is used or intended to be used in an assault determines whether or not it is a dangerous weapon. If defendant threatened to use an object or uses an object in a way that was likely to cause serious physical injury or death, it was a dangerous weapon. You must decide from all the facts and circumstances whether the prosecutor has proved that the firearm in question here was a dangerous weapon. Defendant is also charged in count 10 with a separate crime of possessing a firearm at the time he committed or attempted to commit the crime of assault with a dangerous weapon, during June 2020 through November 2020. To prove this charge, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, that defendant committed or attempted to commit the crime of assault with a dangerous weapon, which has been defined for you. It is not necessary, however, that defendant be convicted of that crime. Second, that at the time defendant committed or attempted to commit that crime, he knowingly carried or possessed a firearm. Defendant is charged in count 11 with the crime of interfering with electronic communication on or about May 25th, 2020. To prove this charge, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, that defendant prevented, obstructed, or delayed by any means the sending of an authorized communication through a telephone line or any electronic medium of communication. It does not matter whether the communication was actually sent or received. Second, that defendant did this willfully and maliciously. This means that defendant did the act on purpose and with the intent to prevent, obstruct, or delay the communication. Defendant is charged in count 12 with stalking. To establish this charge, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, that defendant committed two or more willful, separate, and non-continuous acts of unconsented contact with Alyssa Clark. Unconsented contact means that defendants initiated or continued contact with Alyssa Clark without her consent and includes following or appearing within sight of Alyssa Clark, approaching Alyssa Clark in public or on private property, appearing at Alyssa Clark's workplace or home, entering or remaining on property owned, leased, or occupied by Alyssa Clark, contacting Alyssa Clark by telephone, sending an electronic communication or mail to Alyssa Clark, or placing an object on or delivering an object to property owned, leased, or occupied by Alyssa Clark. Second, that the contact would cause a reasonable individual to suffer emotional distress. Third, that the contact caused Alyssa Clark to suffer emotional distress. Fourth, that the contact would cause a reasonable individual to feel terrorized, frightened, intimidated, threatened, harassed, or molested. Fifth, that the contact caused Alyssa Clark to feel terrorized, frightened, intimidated, threatened, harassed, or molested. Sixth, at least one act of unconsented contact either was committed in violation of a court order or included defendant making one or more credible threats against Alyssa Clark, a member of her family, or someone living in her household. A credible threat is a threat to kill or physically injure a person made in a manner or context that causes the person hearing or receiving it to reasonably fear for his or her safety or the safety of another person. Defendant is charged in count 13 with the crime of first-degree criminal sexual conduct. To prove this charge, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, that defendant engaged in a sexual act that involved entry into Alyssa Clark's vaginal opening by defendant's penis. Any entry, no matter how slight, is enough. It does not matter whether the sexual act was completed or whether semen was ejaculated. Second, that defendant caused personal injury to Alyssa Clark. Personal injury means bodily injury, disfigurement, chronic pain, pregnancy, disease, loss, or impairment of sexual or reproductive organ, or mental anguish. Mental anguish means extreme pain, extreme distress, or extreme suffering, either at the time of the event or later as a result of it. Personal injury means bodily injury, disfigurement, chronic pain, pregnancy, disease, loss or impairment of a sexual or reproductive organ, or mental anguish. Mental anguish means extreme pain, extreme distress, or extreme suffering, either at the time of the event or later as a result of it. Here are some of the things you may think about in deciding whether Alyssa Clark suffered mental anguish. Was Alyssa Clark upset, crying, or hysterical during or after the event? Did she need psychological treatment? Did the incident interfere with Alyssa Clark's ability to work or lead a normal life? Was Alyssa Clark afraid that she or someone else would be hurt or killed? Did she feel angry or humiliated? Did she need medication for anxiety, insomnia, or other symptoms? Did the emotional effects of the incident last a long time? Did Alyssa Clark feel scared afterward about the possibility of being attacked again? These are not the only things you should think about. No single factor is necessary. You must think about all the facts and circumstances to decide whether Alyssa Clark suffered mental anguish. Third, the prosecutor must prove that Alyssa Clark was mentally incapacitated or physically helpless at the time of the alleged act. Mentally incapacitated means that Alyssa Clark was unable to understand or control what she was doing because of drugs or alcohol given to her without her consent. Physically helpless means that Alyssa Clark was unconscious, asleep, or physically unable to communicate that she did not want to take part in the alleged act. Fourth, that defendant knew or should have known that Alyssa Clark was mentally incapacitated or physically helpless at the time of the alleged act. There has been evidence in this case about the defense of consent. A person consents to a sexual act by agreeing to it freely and willingly without being forced or coerced. It is not necessary to show that Alyssa Clark resisted defendant to prove that this crime was committed, nor is it necessary to show that Alyssa Clark did anything to lessen the danger to herself. In deciding whether or not Alyssa Clark consented to the act, you should consider all the evidence. It may help you to think about some of the following questions. Was Alyssa Clark free to leave and not take part in the sexual act? Did defendant threaten Alyssa Clark with present or future injury? Did defendant use force, violence, or coercion? Did defendant display a weapon? If you find that the evidence raises a reasonable doubt as to whether Alyssa Clark consented to the act freely and willingly, then you must find defendant not guilty. To prove the charges of criminal sexual conduct for count 13, it is not necessary that there be evidence other than the testimony of Alyssa Clark if that testimony proves guilt beyond a reasonable doubt. To prove the charges of criminal sexual conduct for count 13, the prosecutor does not have to show that Alyssa Clark resisted defendant. Defendant is also charged in count 14 with a separate crime of using a computer to commit or attempt to commit the crime of obtaining, possessing, or transferring personal identifying information with the intent to commit identity theft. To prove this charge, the prosecutor must prove both of the following elements beyond a reasonable doubt. First, that defendant committed or attempted to commit. Counselor's language missing here.
Yeah, I'm
I
not
think
sure
it's or
why.
attempted to commit the crime of obtaining.
It is, the attempt is built into that one.
First, that defendant committed or attempted to commit the crime of obtaining, possessing, or transferring personal identifying information with the intent to commit identity theft, which will be defined for you. It is not necessary, however, that anyone be convicted of that crime. Second, that defendant intentionally used a computer to commit that crime. Computer means any connected, directly interoperable or interactive device, equipment, or facility that uses a computer program or other instructions to perform specific operations, including logical, arithmetic, or memory functions with or on computer data, or a computer program that can store, retrieve, alter, or communicate the results of the operations to a person. Computer program, computer system, or computer network. Computer includes a computer game device or a cellular telephone, personal digital assistant PDA, or other handheld device. Defendant is also charged in count 15 with the separate crime of obtaining, possessing, or transferring personal identifying information with the intent to commit identity theft on or about September 2023. To prove this charge, the prosecutor must prove both of the following elements beyond a reasonable doubt. First, that defendant did sell or transfer or attempt to sell or transfer personal identifying information of another person. Second, that defendant knew or had reason to know that the specific intended recipient will use, attempt to use, or further transfer the information to another person for the purpose of committing identity theft or another crime. Defendant is charged in count 16 with the offense of unlawfully disseminating sexually explicit visual material of another person on or about September 2023. In order to convict defendant of the crime, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, defendant disseminated sexually explicit visual material of another person. Second, the other person was not less than 18 years of age. Third, the other person was identifiable from the sexually explicit visual material itself or information displayed in connection with the sexually explicit visual material. Fourth, defendant obtained the sexually explicit visual material of the other person under circumstances wherein a reasonable person would have known or understood that the sexually explicit visual material was to remain private. Fifth, defendant knew or reasonably should have known that the other person did not consent to the dissemination of the sexually explicit visual material. Sixth, defendant disseminated the sexual explicit visual material intentionally. And seventh, defendant disseminated the sexually explicit visual material with the intent to threaten, coerce, or intimidate the other person. When I use the term disseminate, I mean posting, distributing, or publishing on a computer device, computer network, website, or other electronic device or medium of communication. When I use the term sexually explicit visual material, I mean a photograph or video that depicts nudity, erotic fondling, sexual intercourse, or sadomasochistic abuse. When I use the term nudity, I mean displaying a person's genitalia or anus, or if the person is female, her nipples or areola. Defendant is charged in count 17 with the crime of knowingly receiving, possessing, concealing, or aiding in the concealment of stolen property on or about November 19th, 2024. To prove this charge, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, that some property was stolen. Second, that defendant received, possessed, concealed, or aided in the concealment of that property. Third, that defendant knew that the property was stolen when he received, possessed, concealed, or aided in the concealment of it. Fourth, that the property was a firearm. I don't know if you'll notice this, but we had a conversation about this morning. There is case law that recently came down that says that defendant knew that the property was stolen when he received it, etc. What you have in the initial packet that I read to you on Monday is that knew or should have known. That should be struck and taken out from your initial packet, so please do not consider that. This is the instruction that you should consider. Councilor Reese?
Agreed, Your Honor.
Yes, Your Honor, thank you.
Thank you. To buy means to purchase property either with money or in exchange for something else of value. To receive means to accept possession of property. To possess means to knowingly have or hold property under your control. To conceal means to intentionally hide, disguise, get rid of, or do any other act to keep the property from being discovered. Defendant is also charged in count 18 with the separate crime of possessing a firearm at the time he committed or attempted to commit the crime of receiving and concealing stolen property. To prove this charge, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, that defendant committed or attempted to commit the crime of receiving and concealing stolen property, which has been defined for you. It is not necessary, however, that defendant be convicted of that crime. Second, that at the time defendant committed or attempted to commit that crime, he knowingly carried or possessed a firearm. It does not matter whether or not the firearm was capable of firing a projectile or whether it was loaded. A pistol is a firearm. The prosecutor must also prove beyond a reasonable doubt that the crimes occurred within Ingham County, state of Michigan. The prosecutor must also prove that the following crimes occurred on or around May 25th, 2020. Count 1, torture. Count 2, assault with intent to do great bodily harm less than murder or by strangulation. Count 7, home invasion, first degree. Count 6, domestic violence. Count 8, interfering with crime report, committing crime, threatening to kill or injure. Count 11, interfering with electronic communications. The prosecutor must also prove that the following crimes occurred on or around the month of May 2020. Count 5, assault with intent to do great bodily harm, less than murder or by strangulation. The prosecutor must also prove that the following crimes occurred on or around January 1st, 2020 through December 31st, 2020. Count 3, assault with intent to do great bodily harm, less than murder or by strangulation. The prosecutor must also prove the following crimes occurred on or around June 2020. Count 4, assault with intent to do great bodily harm, less than murder or by strangulation. The prosecutor must also prove that the following crimes occurred on or around June 1st, 2020 through November 30th, 2020. Count 9, assault with a dangerous weapon. Count 10, felony firearm. The prosecutor must also prove that the following crimes occurred on or around September 2023. Count 14, computers using to commit a crime. Count 15, personal identifying information obtained, possessed, transfer with intent to commit identity theft. Count 16, intentional dissemination of sexually explicit visual materials. The prosecutor must also prove that the following crimes occurred on or around November 16, 2018 through January 1st, 2024. Count 12, aggravated stalking. The prosecutor must also prove that the following crimes occurred on or around November 19th, 2024. Count 17, firearms receiving and concealing. Count 18, felony firearm. Time, however, is not an element of the crime of criminal sexual conduct. The prosecutor does not have to prove the date or time of those offenses beyond a reasonable doubt. These include count 13, criminal sexual conduct, first degree. The prosecution has introduced evidence of a statement that it claims defendant made. Before you may consider such an out-of-court statement against defendant, you must first find that defendant actually made the statement as given to you. If you find that defendant did make the statement, you may give the statement whatever weight you think it deserves. In deciding this, you should think about how and when the statement was made and about all the other evidence in the case. You may consider the statement in deciding the facts of the case and in deciding if you believe defendant's testimony in court. Defendant's intent may be proven by what he said, what he did, how he did it, or by any other facts and circumstances in evidence. You have heard evidence that before the trial, witnesses made statements that may be inconsistent with their testimony here in court. You may consider an inconsistent statement made before the trial only to help you decide how believable the witness's testimony was when testifying here in court. You may consider whether defendant had a reason to commit the alleged crime, but a reason by itself is not enough to find a person guilty of a crime. The prosecutor does not have to prove that defendant had a reason to commit the alleged crime. He only has to show that defendant actually committed the crime and that he meant to do so. Facts can be proven by direct evidence from a witness or an exhibit. Direct evidence is evidence about what we actually see or hear. For example, if you look outside and see rain falling, that is direct evidence that it is raining. Facts can also be proven by indirect or circumstantial evidence. Circumstantial evidence is evidence that normally or reasonably leads to other facts. So for example, If you see a person come in from outside wearing a raincoat covered with small drops of water, that would be circumstantial evidence that it is raining. You may consider circumstantial evidence by itself, or a combination of circumstantial evidence and direct evidence can be used to prove the elements of a crime. In other words, you should consider all the evidence you believe. You should not decide this case based on which side presented more witnesses. Instead, you should think about each witness and each piece of evidence and whether you believe them. Then you must decide whether the testimony and evidence you believe proves beyond a reasonable doubt that the defendant is guilty. You have heard testimony from a witness who's a police officer. That testimony is to be judged by the same standards you use to evaluate the testimony of any other witness. Possible penalty should not influence your decision. If you find defendant guilty, it is the duty of the judge to fix the penalty within the limits provided by the law. Similarly, you heard testimony yesterday from defendant about where he's been, and that should not influence your decision in any way. If you want to communicate with me while you're in the jury room, please have your foreperson write a note and give it to Brian. It's not proper for you to talk directly with the judge, lawyers, court officers, or other people involved in the case. As you discuss the case, you must not let anyone, even me, know how your voting stands. Therefore, until you return with a unanimous verdict on each count, do not reveal your voting or anything else you're discussing to anyone outside the jury room. When you go to the jury room to deliberate, you may take your notes and you'll be provided these full instructions. We'll take a couple of minutes. You can see we've got a couple of corrections that are minor, and then the copy machine needs to make a dozen copies, so it'll be probably 20 minutes or so. If you want to look at any or all of the reference documents or exhibits that have been admitted, just ask for them. They're all organized and ready for you. We have a clean computer if you want to plug that in and see any of the electronics that were put on the screen. The gun, however, I do not let that go in with you. It's not loaded, but I don't want anybody to feel uncomfortable. So if for some reason you wanted to see the gun, you need to let us know. I'll bring you in here with the deputy with us, and then you can take whatever time you need to review it and then refrain from talking about it until you go back to the jury room. When you go to the jury room, you'll be given a written copy of the instructions I'm now reading. As you discuss the case, you should think about all of my instructions together as a lie or to follow. You should first choose a foreperson. The foreperson should see to it that your discussions are carried on in a businesslike manner and that everyone has a fair chance to be heard. During your deliberations, you will not have your cell phones or other communication equipment until we recess. A verdict in a criminal case must be unanimous on each count. In order to return a verdict, it is necessary that each of you agrees on that verdict. In the jury room, you will discuss the case amongst yourselves, but ultimately, each of you will have to make up your own mind. Any verdict must represent the individual considered judgment of each juror. Counsel can ask me to poll the jury once the verdict is read. Polling the jury means that I will ask you individually, on the record, 2 questions that you will each have to answer. The first question, was the decision that was just read your individual decision? Second question, was the decision that was just read the decision of the whole jury pool? It is your duty as jurors to talk to each other and make every reasonable effort to reach agreement. Express your opinions and the reasons for them, but keep an open mind as you listen to your fellow jurors. Rethink your opinions and do not hesitate to change your mind if you decide you were wrong. Try your best to work out your differences. However, although you should try to reach agreement, none of you should give up your honest opinion about the case just because other jurors disagree with you or just for the sake of reaching a verdict. In the end, your vote must be your own, and you must vote honestly and in good conscience. If you have any questions about the jury instructions before you begin deliberations, or questions about the instructions that arise during deliberations, submit them to me in writing, and you have those sheets that you wrote the questions on, make sure they're legible, give them to Brian, and you'll get your answer. Defendant is charged with 18 counts. That is with the crimes of torture, assault with intent to do great bodily harm less than murder or by strangulation. Assault with intent to do great bodily harm less than murder or by strangulation. Assault with intent to do great bodily harm less than murder or by strangulation. Assault with intent to do great bodily harm less than murder or by strangulation. Domestic violence, home invasion, first degree. Interfere with a crime report, committing crime, threatening to kill or injure, assault with a dangerous weapon, felony firearm, interfere with electronic communications, aggravated stalking, criminal sexual conduct, first degree, multiple variables, computers using to commit a crime, personal identifying information obtained, possessed, transfer with intent to commit identity theft, intentional dissemination of sexually explicit visual material, weapons, firearms, receiving and concealing, and felony firearm. These are all separate crimes, and the prosecutor is charging that defendant committed all of them. You must consider each crime separately in light of all of the evidence in the case. You may find defendant not guilty or guilty of all, none, or any combination of these crimes. A verdict form has been prepared listing the possible verdicts. I don't think I need to reread all 18 counts, I just stated them. But you will each have your own set of instructions. However, as to the verdict form, it is 5 pages long. There's only going to be one copy. You will each have access to it, but it is the duty of the foreperson to fill it out. And then when you've reached a verdict and come back into court, I will ask that the foreperson was chosen. I will ask the foreperson to stand and then read in a nice loud voice the verdict on each count. There is a space at the end that has a place for the foreperson's signature and the date. This becomes an official part of our record. And below each count, it said there's a line and it says not guilty, and then under that there's a line and it says guilty of whatever that count is. On behalf of the people, are you satisfied with the reading of this set of instructions?
People are satisfied, Your Honor.
On behalf of defendant, are you satisfied with the reading of this set of instructions?
Yes, Your Honor. On the other hand, my copy suggested criminal jury instruction 4.16 intent. I don't believe the court read that.
May I see that?
I believe we did.
May I see that?
Yes, Judge.
I think I did read it. Doesn't hurt to read it again. I'm pretty sure I read it, but I certainly can read it again.
It's a short one.
And this is a short one. Defendant's intent may be proven by what he said, what he did, how he did it, or by any other facts and circumstances and evidence.
Nothing further. Thank you.
Thank you. Okay. At this time, we have our clerk, and I've said this, I think, a couple times, but 2 of you will be called. It is totally random. I have, over my 22 years, had a number of jurors, because now you've heard the whole case. You're invested in it. And I've had a number of jurors, after they get discharged, say, did I do something wrong? I really wanted to say, no, it's totally random. So there's kind of like playing bingo. She pulls out 2 numbers. Now, as I've said, I don't know what other judges do, and I don't care. What I do is you will be released, but you cannot talk about this, or just go about your business. Forget about all of this right now. And then Brian will call you when we have a verdict. You can talk about it whenever you want with whomever you want, if you choose. But Brian could also call and say, please return. We need you to replace someone who's had an issue. And if we needed one person, that the person would be random of those two, it'd be put in the jar and randomly pulled out. So, at this time, who are the two that will be discharged from deliberation?
Juror 3. And juror 5.
All right. So, any questions? Just make sure that Brian has your numbers. I think he has all your numbers, but just make sure that he has your number. We will call you when there's a verdict, or as I've said. All right, thank you. Just stay seated for a few moments. Please raise your right hand and state your name.
Brian Ray.
Do you solemnly swear or affirm that you will, to the utmost of your ability, keep the persons sworn as jurors on this trial from separating from each other, that you will not allow any communication to be made to them orally or otherwise, that you will not communicate with them orally or otherwise except upon order of this court, or to ask them if they have agreed upon a verdict until they are discharged, and that you will not, before they render their verdict, communicate to any person the state of their deliberations or the verdict they have agreed upon, so help you God.
I do.
Thank you.
All rise.
Just a moment. Yes. Before we go in, I need you to be done about 11:30 today, and then Monday would be 9 to 5. Again, there's no limit on your deliberations. Before you go in, does anybody have any questions? Okay, now you may go, Brian.
All rise.
About the 30 seconds.
Do we have some matters right after this? Yes, we do. Okay.
Files are up top, Judge Warren. Schedules, they're right there on the corner of the bench. They're gonna be starting with red wire.
All right, looks like we have,
Are we done with this one, like we're off record?
just a minute, yeah. Is there anything else for the record?
To be clear, I redacted, I think it was 3 exhibits that had the personal identifying information on the social security card and driver's license. I also have a typed up exhibit list. I will make sure that defense approves of it, but if the court would not mind that going back with the jury, given there are over 70 exhibits.
I think that would be wise. Agreed?
Yes, Your Honor.
You may all be seated, and, yep, and then, so that will go back, and anything else? I need your cell phones, I need you to stay within, 10 minutes of here. It's only till 11:30, it's another hour, then we'll see what we do, and then, they'll proceed Monday at 9. I just need to know that you're about 15 minutes away, stay in your offices.
Absolutely, and just to confirm, you want the firearm to be put back in lockup while they're deliberating, as opposed to
Absolutely,
being in your courtroom.
absolutely, because we've got, I think, 3 other matters after this, so I do need the firearm locked up. Is there anything else?
No, not from the people.
Just a minor issue, Your Honor. If I could, I guess, move the court to include not only the signature of the foreperson, but underneath that, the printed name. Oftentimes it's not.
Sure, if we can't read it, yeah, we can,
Thank you.
we'll take care of that at the end.
Thank you. Nothing further.
No issue with that, Your Honor.
Okay.
Thank
So we're off the record
Thank you.
until we're standing the call of the jury. Thank you. All right, and then,
I need to do the gun.
yeah, that's fine. Everybody's gonna get organized to the next matters.
Choose my-
You're good.
Oh, no, Bart, that's what you do that time.
Okay, that's fine.
Here, I got you. Perfect. No problem. We're gonna do a top of that. That is the nice thing is that we, no matter what the result is, we get to talk with them, so we're not just for the rest of our lives going, but why?
In the measures.
Yeah.
Between.
In between.
No, no.
Also, I'm gonna change every word of victim to a list.
Oh, okay. And. Why?
I just have to wait for the court reporter. And is this, Mr. Peterson? Yeah.
Mr. Wickwire, Your Honor.
Wickwire, okay.
Thank you.
This is actually private. Private hearing, Your Honor.
Oh, yes, first.
Your Honor, can we approach?
You may.
Yeah. my understanding. Or 7.1.
So,
7.1.
7.11. My knowledge.
Oh, check.
It's on the like schedule.
Was he eligible for 74?
I might be mistaken, but mine, because.
Yeah, no, Mr. Wickwire, prior drug convictions, Your Honor, I don't believe he was.
I don't think there's 74.
I apologize, Your Honor.
It's okay,
Yes, that makes
because
sense.
he had a have as far as I remember,
Yes.
so I don't think,
Never mind, Your Honor.
okay. no
For whatever
problem.
reason, it wasn't on.
It's okay.
Yeah.
That was last minute.
This is going to be, Wickwire. Wickwire. Everybody ready?
Okay.
This is docket 24806 FH. People of the state of Michigan versus Randy Lee Wickwire. Counsel, your appearance for the record.
Good morning, Your Honor. APA Barb Buxton on behalf of the people of the state of Michigan.
Good morning, Your Honor. Jacob Sarts, the fourth Assistant Public Defender here on behalf of Mr. Wickwire. He's present at the podium. He's standing to my right.
Good morning, sir. Please raise your right hand. Do you swear or affirm the testimony you're about to provide will be the truth, whole truth, and nothing but the truth, or penalty of perjury?
Yes, ma'am.
Thank you. Put your hand down. Sir, you pled guilty to controlled substance possession of controlled substance known as methamphetamine, punishment by 10 years. You were placed on probation. I now have a probation violation. Have you reviewed it with your client?
We have, Your Honor.
And the probation agent is here, Dan Brown?
Yes, Your Honor.
All right, and are there any amendments?
No, yes, Your Honor. There is an amendment to count 2. It should state that anytime thereafter he failed to report to probation.
Any objection?
That's been disclosed, Your Honor. I've had an opportunity to discuss it with Mr. Wickwire. The amendment would change the count from a technical violation to a non-technical violation of absconding. Mr. Wickwire has been advised of this, and you understand what that change would be, correct, sir?
Say yes, sir.
Yes. Thank you.
Thank you. Sir, have you taken any medication yesterday or today?
No.
Are you supposed to be on medication you're not on?
No.
Any sign of fever, COVID, or other illness?
No.
All right. And going through any kind of withdrawal?
No.
All right, very good. Sir, I have allegations as follows. Count one, on or about August 13, 2025, and August 18, 2025, you failed to complete a drug test at AverHealth. Count two, on or about August 19th, 2025, defendant failed to report to probation and any time thereafter. I had put you on a probation term of 24 months, it appears, and that had not yet run. And are you awaiting further arraignment?
We do, Your Honor.
Will this
Thank
be
you.
a plea or a hearing?
It will be a plea, correct, Mr. Whitmire?
Yes, ma'am.
Thank you.
All right, sir, as to count one, well, let me just ask you this first. Are you pleading of your own free will?
Yes, ma'am.
And you discussed all of this with your attorney?
Yes, ma'am.
No one forced, threatened, or coerced you to plead?
No, ma'am.
And you've been satisfied with the representation of your attorney?
Yes, ma'am.
As to count one, on or about August 13 and August 18, 2025, failure to complete drug testing at AverHealth, how do you plead?
I'm guilty.
As to count two, on or about August 19, 2025, failure to report to probation and any time thereafter, how do you
Guilty.
plead? Sir, you understood the terms and conditions of probation. You were to complete any treatment, testing, and show up to probation regularly as requested, and you failed to do those things. Is all of that correct?
Yes, ma'am.
Did anything happen to you where you were hospitalized or something happened where you couldn't comply with the terms?
At the time, ma'am, I lost my place of stay and my phone got stolen and it took me about a month to get a new phone.
Okay, but still you didn't call, you
You're
didn't
right.
walk here, didn't get a ride, you
You're-
didn't borrow a phone.
You're correct.
Okay, appreciate you saying that. A lot of times people give me a whole list of excuses, so
Nope.
you understand that,
Yep.
and probation could have even helped you with those things.
Any probation, what?
Could have even helped you with those things or work out those things. That's what this, probation's not a punishment, it's actually meant to help you get better, but you gotta do the work.
Yes, ma'am.
All right. I find by preponderance of the evidence in his own admission that defendant has violated probation. Count one and two will enter. May we go into immediate sentencing?
Yes, please, Your Honor.
What is the recommendation from probation?
Thank you, Your Honor. At this time, Mr. Wickwire was doing very well. When he was released in May of 2025, we had many conversations about probation and how probation could help him. He was testing 3 times a week. Once he was released from the jail, all negative. He had not missed a test, and he was engaged with peer recovery through Michigan Department of Corrections and Community Mental Health. He also was referred by myself to go to LCC for their modern warehouse free training job opportunity, which he was engaged in that. So it was kind of surprising that he just didn't or stopped showing up for probation. However, at this time, probation is willing to continue to work with Mr. Wickwire if he would like the help. He has served 311 days jail total on this docket. So probation would recommend that he be serve the 311, be released, and continue probation.
Does that include the 77 initial days plus the new days?
Correct. He was in custody from 7/24 to 5/7 of 2025, and then 14 days on this bench warrant.
Thank you. On behalf of the people, what would you like me to know?
Your Honor, the people would agree with probation.
Thank you, Your Honor. On behalf of Mr. Wickwire is very sorry he stopped reporting. He just ran into a real rough stretch after he got out from jail. He lost his housing, he lost his employment, and he lost his phone. And he regrets not reporting back to probation once he got a phone, Your Honor. But, you know, to his credit, he's been maintaining his sobriety. To his credit, Your Honor, he would raise another opportunity to successfully complete probation if Your Honor believes that's the appropriate sanction here. And he's trying, Your Honor. He's trying really hard. He's just run into some personal challenges on the outside, Your Honor, but he understands the importance of maintaining his sobriety, and he would like to explore opportunities to see if he might be eligible for additional housing. options, maybe support that way, and then he will certainly pursue employment if he gets released and make sure that he complies with all of your honor's orders if your honor grants him another opportunity at probation. Thank you.
Sir, what would you like me to know?
I don't think there's anything for me to say that you don't already know. I mean, I would love it. I would love it on another opportunity. I would. But that's gonna be all up to you.
Well, I know that, but tell me, are you committed to your sobriety?
I am. I've been sober. The staying sober hasn't been the problem. It was the housing situation and when my phone got stolen. And when I just didn't know what to do after I got the new phone and everything.
Okay, part of your rehabilitation is, I need help. You need to ask for help.
I'm not,
Yeah, I
that's
know.
something I've never been good at doing.
Well, when you learn that lesson, your problems, your load will be lighter. There's lots of people in this community who will help you. First and foremost, probation. They can help you unlock doors that you don't know are available to you. And there are some new homeless shelters that have opened that are brand new and could give you a bed temporarily till we find a place for you, or you find a place, you get a job. There's lots of help in this community. You first have to say, I need help. That is not a sign of weakness. You're in the majority. Most men think that if I ask for help, I'm weak. But you know what? Flip that script in your head. Asking for help is a sign of strength.
Okay.
Does that make sense to you, sir?
Yes, ma'am.
Because all you do is bring yourself down when you don't ask for help. You get picked up by law enforcement, you sit in jail, you're in that jumpsuit,
Yeah.
you get in front of me, that can't be fun, right?
No, ma'am. Sure ain't.
So tell me about work and options. Were you getting to the point of holding a job or getting trained, what?
Well, I did attend the class, like she said. I went through it, I got all the certificates for it, and it was like right after that class happened is when all this situation happened. So I knew I had the warrants and I couldn't really progress any further with it. But I do have, every single week, the Michigan Works Office, they've been sending me information for jobs. So
Where are they sending it to if you're homeless?
my email,
Okay, so you have your phone back?
I have a new phone, yes, which I have a new phone number, which I would have to give to Ms.
Okay.
Brown.
Okay, so you get 365 days credit for a 311 balance held. Here's what you're going to do, sir. You are gonna get real. Because otherwise you could go to prison.
Yes, ma'am.
If you want to get trade school and all the things you ought to be doing done behind bars, happy to do that. It's up to you. Your choice, your decision. Free man or imprisoned man. You're almost out of jail time.
Yes, ma'am.
So today's lesson is, I will ask for help.
Yes, ma'am. I'll ask for help.
Good. Because essentially what you've done by not following the orders of this court is ask for help. You're saying, extend me, I need help. If you would have just asked sooner, we wouldn't be here. Does that track with you?
Yes, ma'am.
Okay, so you need to provide your phone number to probation
Okay.
and every address within 24 hours, address change. Do you have a place to go to, or are you going to be in the shelter for now?
I'll have to be in a shelter for now.
Okay. I don't think we need to amend any orders. He needs to be re-engaged with whatever employment skill programs we have. And he needs to apply for some kind of temporary housing. I don't know what the options are, but we need to work with them on that. Is there anything else that you need that we're not addressing, or?
Not at this time that I could think of.
Okay. So you'll probably be released today. I don't know if probation will still be here. Can you come back here on Monday?
Yes, ma'am.
Does that work with your schedule?
Yes, Your Honor.
Okay. We're gonna get you back on track, testing, doing all the things you're supposed to do, ask for help.
Yes, ma'am. Thank you.
If there's any additional treatment, let's get them there, or any additional education for employment, let's do that.
Yes, Your Honor.
I look forward to signing your discharge successfully from probation and you getting on track with your life. The only one that can put it on track is you. Good luck to you, sir.
Thank you.
Thank you, Your Honor.
To get your.
Okay.
Next matter.
Peterson's also in lockup, so we're gonna have to wait a little bit.
He's up.
Okay.
Oh, yeah.
Your Honor, may I approach?
You may. Okay, this is my copy.
Yes.
Right, can we get a hearing device? for
Yeah.
Mr. Peterson, please? So they can.
Are you ready, counsel?
Yes, Your Honor.
And
Thank
you're
you.
getting a listening device for him, so.
Oh, do we need, oh, we
Yeah.
Okay.
Was this working for you earlier, Mr. Freeman?
That was working for me.
Just the headphones, maybe?
Well, we should have 4 sets.
We have 3.
Someone took one of ours then. Well, they all work.
I bet Dale took it.
Maybe. Hello?
But Mr. Freeman's Mr. Freeman.
Hello? Can you hear it?
I'll go reset it real quick. Because Mr. Freeman's was working earlier and it's not working now. Give me like 30 seconds, I'm gonna reset it. headphones.
Is it working?
This one is not, but this one is.
Is it too loud?
Oh, God. That one's working, Judge.
Can you hear now, sir?
Yes.
Thank you.
Can you hear me, sir?
Yes, ma'am.
All right, very good. This is docket 24-651 FH, people of the state of Michigan versus William Benjamin Peterson. Counsel, your appearance for the record.
Good morning, Your Honor. APA Bart Buxton on behalf of the people of the state of Michigan with probation.
Agent Michael Province on behalf of Agent Stephen Green for probation.
Good morning, Your Honor. Jacob Sarts, the fourth Assistant Public Defender here on behalf of Mr. Peterson. Mr. Peterson is present at the podium. He's standing to my right.
Thank you, sir. Please raise your right hand. Do you swear or affirm the testimony you're about to provide will be the truth, whole truth, and nothing but the truth, and the penalty of perjury?
Yes, ma'am.
Thank you. Put your hand down. Sir, you pled guilty to count 1, controlled substance, possession of a controlled substance known as methamphetamine, punishable by 10 years. You were placed on probation. Do you recall that?
Yes, ma'am.
And you were placed on probation for 24 months with certain conditions. I now have allegations, 3 counts. There's an amended probation violation. Counsel, you've gone over those?
We have, Your Honor.
Sir, have you taken any medication yesterday or today?
No, ma'am.
Are you supposed to be on medication you're not on?
No, ma'am.
Any sign of fever, COVID, or other illness?
No, ma'am.
And sir, I have 3 allegations. Count 1, on or about October 22nd, 2025, defendant failed to enroll in complete opiate methamphetamine specifics, the OMS program at TRICAP. Count 2, on or about May 22nd, 2026, defendant was in possession of methamphetamine. Count 3, on or about October 22nd, 2025, defendant failed to report to probation or any time thereafter. Are those the allegations that you reviewed with your client?
Yes, Your Honor. We received an amended information this morning, but I have had the opportunity to explain what the amendments are to Mr. Peterson this morning, and we had anticipated this after conversations with his probation officer. Thank you.
And are you waiving further arraignment?
We do, Your Honor. Thank you.
Sir, do you understand the 3 allegations?
Yes, ma'am.
And is it your intention to plead to those?
Yes, ma'am.
And you're doing so of your own free will?
Yes, ma'am.
No one forced, threatened, or coerced you?
No, ma'am.
Your Honor, I would note this is going to be a plea to count 1 and to count the added amended count of absconding on 10/22/2025. As it relates to count 2, Your Honor, that depiction, the allegations of possession, Mr. Peterson has a pending matter at the 54A
I
District Court.
see. Is that,
That is correct, Your Honor, and it's currently set for preliminary examination on June 11th.
all right, so let me, count 2. I'm simply going to strike count 2.
Thank you, Your Honor.
It's a bit redundant to have this here and then come up, so we'll deal with all of that if and when it comes up.
Thank you, Your
Sir, you'll be pleading to count 1 and count 3, is that correct?
Yes, ma'am.
And you're pleading of your own free will
Yes, ma'am.
after you spoke with your attorney,
Yes, ma'am.
and you've been satisfied with the representation of your attorney?
Yes, ma'am.
And counsel, are you also the attorney in the pending matter?
Yes, Your Honor, myself and Vita Tesmer-Rosti.
Thank you.
Thank you.
Sir, as to count one, on or about October 22nd, 2025, failure to enroll and complete the OMS program, opiate methamphetamine specific program at TRICAP, how do you plead?
Guilty.
And as to count three, on or about October 22nd, 2025, failure to report to probation then and any time thereafter, how do you plead?
Guilty.
Did anyone force, threaten, or coerce you to plead?
No, ma'am.
And sir, you understood the terms and conditions of probation?
What I was told, I kind of heard that they're going to terminate the other one.
I do.
I can plead guilty to the other ones. I can get help. I want help.
Sir, wait a minute.
I mean, that,
Can you just start over, but I'm asking if you understood the terms and conditions of probation?
Yes,
Okay, and you understood that you needed to complete any programming that I ordered?
yes, ma'am.
And you failed to complete the OMS program?
Yes, ma'am.
And you also failed to report to probation since October 22nd, 2025?
Yes, ma'am.
All right, was there anything that prevented you, like a hospitalization?
I'll say this way,
Sir, you had just enunciate, the court is not understanding you.
I'm sorry, I'm trying to tell you what I think I need, if that's what you're asking.
That's not what I'm asking.
Okay.
Is there anything that prevented you? Is there anything that stopped you from complying with these orders, like were you in the hospital?
No, ma'am.
All right. I find defendants pleas been freely, voluntarily, knowingly, and understanding we may also find if there are sufficient grounds by preponderance of the evidence, his own admission to enter counts 1 and count 3, count 2 is dismissed. May we go to sentencing?
Yes, please, Your Honor.
What is the recommendation of probation?
Your Honor, probation recommends the defendant's probation be revoked and he be sentenced to 365 days jail in the Ingham County Jail. Credit for 73 days served. The defendant was ordered to complete TRICAP following sentencing and was being transported to TRICAP when he absconded from their van, thereby placing himself and other people in danger by fleeing outside of the vehicle in the roadway. The PSI indicated that the defendant had admitted to lying to police at his instant offense for this probation about swallowing heroin in the hopes that they would take him to the hospital so he could abscond there, but for the fact that the police did not have officials to stand with him, he would have carried through with it. And then the current police report in the pending matter in 54A also indicates that the defendant attempted the same conduct. The defendant's conduct has shown that he is not willing to comply with any type of supervision or treatment, and he does appear to need that treatment, so probation would recommend he get that treatment in custody.
Thank you, counsel.
Thank you, Your Honor. Mr. Peterson is going to be requesting another opportunity, Your Honor, to try inpatient again. Without getting into the specifics of the allegations on 5/22/2026, of course, Mr. Peterson is presumed innocent, but it's safe to say, Your Honor, that Mr. Peterson has struggled with substance use for years. He made a very poor decision when he absconded from TRICAP, and he understands that what he did was wrong there. And Your Honor, he has had some time to think and reflect on his actions. And he realizes now that he really needs the help at this point. We are attempting to negotiate a possible plea deal for him on the pending charges, Your Honor. Our goal would be to see if we might be able to work out a resolution that would potentially allow him an opportunity to pursue rehab on that file. So simultaneously with this, Your Honor, I would respectfully request that Your Honor give him another opportunity here to try rehab, whether it's inpatient or outpatient. Mr. Peterson is a skilled tradesman. He was working, and he can reestablish those connections in the community. He's an older gentleman. He's in his mid-50s, and he's at a crossroads in his life. He the addiction, unfortunately, Your Honor, is something that he has really struggled with. So respectfully, Your Honor, I certainly understand the probation position on this. But having Mr. Peterson just sit in jail with the limited treatment options available at Ingham County Jail, which there are treatment options available for him, and that's to the jail's credit. But respectfully, Your Honor, perhaps Mr. Peterson, if given an opportunity, and will be successful this time if he goes into TRICAP or Bear River or something a little more intensive, Your Honor. Thank you.
Sir, what would you like me to know?
I have to guess, I do have a problem with methamphetamine. I've been had problems with that. It's a really good program. I talked to a couple people and it's like Bear River. I just hear a lot of people go to Bear River, don't even want to come back here. They're doing really good there. That's why I'd like to go there. And go to Rise, because I never had my own house or nothing like that. I always live with people and that's been my problem too. I don't know how to go about it. I heard Rise is a good thing to go to. And I just want to better myself for myself and not anybody else, just for myself. So I can get back by it. I'm, like you said, I'm older, I'm 54 years old and I'm pretty much over this going to jail. And I just want to better my life and I'm ready to do it one way or another. That's how I want it. That's what my ambition is.
Did you want something added?
Your Honor, I just wanted to state, as far as the defendant's willingness to go back to treatment, as previously stated, the police report from May indicated that he was attempting to do the same thing as absconding.
I got it.
As far as treatment programs, the OMSP program at TRICAP is the best for him, and the defendant failed to even make it to the facility to do so.
Thank you. On behalf of the people.
I would agree with probation, Your Honor, given Mr. Peterson's history. He's been to jail 7 times at this point, and it looks like he's been to prison once, based off my brief review of the PSI. This has been a drug issue that he's been dealing with for many years. We attempted to try and get him help going to TRICAP, and he fled him during transport. So I would agree with probation. Thank you.
Anything further on behalf of the client?
Nothing further, Your Honor. Thank you.
Sir, it looks like from your own admission in the pre-sentence investigation report, you had one real job. The rest, you just do odd jobs to probably get your next fix. You also have had, let me see, 8 children, and you've not provided for them. So the mothers of these children, and I'm sorry, I understand you lost one child. The mothers of these children have been solely providing, and then one of the mothers, you lost your child into the system because she was also using drugs.
Yes.
Sir, at what point do you realize that your addiction isn't just affecting you, it's affected your family, your community?
I haven't, it's hard out there when you get out, and then you hang out. People saying people come hang out with you, and I don't want them hanging out, I don't really need more friends out there. I need help, and I don't know how to go about it. And that treatment and stuff, and that's all I want is, I can take care of my children. I'm proud to have my kids come over to my house for Christmas and stuff like that. If I have a house, I don't have a house now for my kids even come see me, so it's kind of embarrassing. And I try to take care of my kids best I can. I give them money when I can. I give them money.
When you climb in bed with a woman and there's a potential baby and you did that 8 times, you think about the house then, not after you're addicted and the kids are out there without a dad.
Yeah.
You're a little bit late to the story here, sir.
Yeah, I know.
And then you have a sibling that you lost through an accidental overdose. You've been using, probably you lost that job through poor attendance because of addiction, because you had a really good job. We tried to treat you and you didn't want that. You didn't change your life in terms of hanging around the same old people. They come around, you're buddies with them and you get the next high. You've been in front of a judge 19 times. I have 19 offenses. Now granted, some things were dismissed, but you have, assault. There's lots of charges here, sir. I And most of them are drugs and drug-related things. We tried, the only one who didn't try is you. Sir, I am giving you, I could send you to prison, but what I'm gonna do is give you 365 days jail, revoke probation unsuccessful, 73 days credit while you're in jail, you'll be seen by medical. You will be part of AA, NACA, whatever treatment programs we have. And I don't know in the jail if they have any trade school or education available, but you should complete CATS, any trade school they offer, any housing information. Do you even have a social security number or ID?
Yeah, I don't have an ID. I haven't had an ID in 10 years. I've been in South Korea.
Well, where you tell the jail that before you leave, you need to have an ID, they can help with that, okay?
Yes,
Or social security, whatever they can do, okay?
yes.
No regular release, no tether release, no trustee status. Sir, you said it yourself, you're too old for this, and we've got yet another count coming up. I don't know what I'll do with that. But this has to stop, because it's jail or a body bag at this point. Or a prison or a body bag. I don't see the middle road, because it doesn't seem that you really want it. You want to talk fast, and you want everybody to believe you, as they always have since you were probably a teenager. They just believe what you have to say. I don't believe it. I deal in evidence, and the evidence is you need a whole lot more help, and you're not willing to put in the time and give up your old friends and your old life, because some part of you really enjoys it, and you're just getting by. No more getting by. Let's get sober and live the life God gave you, because otherwise, he's gonna take it from you. I don't know what you're gonna see to him, or say to him when you see him. What are you gonna say? I'm sorry I wasted my life? Have you ever thought about that?
No, ma'am.
Every child is born to greatness. You still have an opportunity to achieve greatness if you want it.
I do, ma'am.
Then prove it, sir. I deal in evidence.
I told.
Right, and you don't even need to prove it to me, you need to prove it to yourself. You need to look in the mirror every day and say that you want to live and that you're worthy and that you're going to achieve something good. And every day just take a little step toward sobriety, toward being good, toward uplifting your life. It's your life. If you want to throw it away, you can do that, but you won't do it under my watch. You have 42 days to appeal and to request appellate counsel.
Do you acknowledge receipt of this form, sir? Do you have a form in your hand?
Yes.
That is your notice of your appellate rights. Do you acknowledge receipt?
Okay.
Have you received the forms?
Yes.
Thank you.
Thank you, that's all for the record.
Thank you, Your Honor.
I think I had a year, right?
Yes, you can. With 77 days credits.
Huh?
With